Someone make it make sense.
Probably a couple.
What is up, squirrels of the world? I hope y'all are doing well. We are having heavy snow here in Greensboro, North Carolina, which is a rarity these days for us. So pleasantly surprised. It's always funny to me, though, how people can't drive in the snow. And I lived in Boone for like 11 years, which is in the mountains of North Carolina. And we got, it's an anomaly, right, for North Carolina. It's more like somewhere up north where, you get dumped on with tons of snow for like 8 months straight out of the year. And not only that, but it's all hills, right? It's all hills and curvy roads because mountains. So it's just so funny because earlier I ran to the grocery store, and I mean, there's snow, but it's not like a lot of snow. You know what I mean? Like I drive a Prius and like it's fine. The roads are fine even without being plowed. I don't even have to go any slower than usual. And it's like driving home from the grocery store. It's like all the other cars are like just like pulled over with their hazard lights on. Like, it's the end of the world. It's hilarious. And I'm like speeding past in my Prius, like y'all are crazy. So anyway, it's funny. But I know there's a lot going on. We've got the snow, and then there's, of course, the wildfires. And I know we have some California squirrels. I hope that everybody is safe if you are in any of those areas. Well, regardless of where you are, I hope you're safe and not impacted negatively in terms of any of those wildfires, especially. So those of you guys who are here for the Kohberger coverage, you may have noticed that I initially had made this stream, like, I think it was right around New Year's Day-ish or something, because I'd been waiting for the new court filings, to come in. And what happened was I'd been sick, and then I had completely lost my voice. And if you guys have been here for other streams, you've already heard me mention this, but starting on I think it was like right on New Year's Day, I had laryngitis, and I completely lost my voice 100% for a solid week. I couldn't actually make any sounds. It was really crazy. And then my voice over the next couple days after that has been coming back anyway. So now my voice isn't fully normal yet, but I have a voice. And so a lot has been going on. But in the meantime, while I couldn't stream because I couldn't talk, I was working on stuff for all the different cases I'm covering, but especially for this, I've got some stuff put together for you guys, like visual aids, if you will, working with the timeline and looking at the DNA and the Elantra. So we're going to go through those as well as all the court filings, which of course I needed to be able to read. So one of the things that's interesting is this. So if you look at the scheduling order here for the I.C.R 12 motions. Now, the I.C.R 12 motions, that's Idaho court that's the administrative rule, I believe. Or no, that's I.C.R. So this is Idaho criminal rule. Yeah. Okay. So 12. So that's pretrial motions such as motions to suppress, right? So remember, the hearing that is on the 23rd, and as we learn in one of these filings we'll take a look at, actually, apparently they're expecting it to take 2 days because they have the 23rd and the 24th. Anyway, that's the motions to suppress. So that is going to be really interesting. Now, remember, there's also separately and adjacent to, there's also the Franks, right? Which Judge Hippler has not ruled on that yet. But that is going to be really about the IGG. And as y'all, I'm sure, are aware, all that's going to be fucking sealed, but the ruling on whether or not he's going to grant that hearing, that will not be sealed, and we'll know when the hearing is. But anyway, so in other words, the hearings on the 23rd and 24th with the motions to suppress, I'm sure IGG will come up, but it's going to be like what we've already been covering with the motions to suppress and the state's object back and forth, right? And again, a lot of the for some of those, the memorandums and whatnot, company or the exhibits, some of that is also sealed. But there is still a lot that will go on. And I'm really excited to see what will come of that. But here's what I wanted to point out. So today is the 10th. All right. In preparation for the hearings on the I.C.R. 12 motions scheduled to begin on January 23rd, here's the order, right? Defendant shall disclose its witnesses, exhibits, and expert opinions by January 9th. Now, I just checked the docket that has not posted yet, and I haven't seen them file for an extension for that or anything like that. My guess is that sometimes when they, they submit these court filings, but sometimes it can take a couple days for it to actually get posted online. Sometimes it's pretty much the same day. Other times it takes a couple days. Recently, there's a couple court filings that came up that were from December 31st, and those just popped up yesterday. So who knows? But but we've got so much to cover that I didn't want to wait any longer. Initially, I was like, well, I may as well wait for because that's going to have the witnesses. Now, why am I all excited about that? Here's why. Because right here, this subpoena. So this is the subpoena. Now, of course, it's been redacted, right? To blank. So it's a subpoena Duces Tecum. So it means you have to show up and bring shit with you, right? So you are hereby commanded that laying aside all excuses, you appear in the district court, blah, 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 on, and there it is, the 23rd and the 24th. So there you go. So I'm thinking they're expecting this to take 2 full days. And in all caps, you are further notified that if you fail to appear at the place and time specified above, that you may be held in contempt of court and that the agreed blah, blah, and all this shit, right? And so it's like super serious. So now this is the subpoena, but more than likely, almost definitely, right? They sent more than one of these out. By they, I mean the defense. And so when we get this document here that I was waiting for that hasn't posted yet, right? Where the defense disclosures, it will have the witnesses that have been the recipients of those subpoenas will be disclosed, right? And so any day now, I will keep refreshing it. And as soon as we have that, because I'm really curious. Some of my guesses would be, what is it? FBI agent Ballance or whatever, because they talk about him a lot as it pertains to I believe it's with the cast data. I believe they talk about Ballance a lot there. Then there's also, of course, Agent Imel, who was the one who was in charge of the Elantra years or whatever. Those are 2 very likely potential witnesses. Also, I would say the 2 different law enforcement officers from WSU, and we're going to delve more into that, so don't worry. But those, so like going through all this, I'm like, it's like there's people where it's like we need to have heard from these people, right? And in my opinion, it's like 2 of those people are the 2 WSU officers that are referenced in the Brett Payne affidavit, but then also the FBI agent that dealt with the Elantra, and that's Imel, and then the FBI agent who dealt with the cell data, and that's Ballance, I think is how it sounds like. Well, they say Ballance, so that's what it sounds like. So, okay, so that's the first things I wanted to take a look at. So now, let me zoom in. Okay. So up next, this was filed on December 19th, but it did not post until after Christmas. I think around like New Year's or whatever. Okay. Well, we don't need that. Okay. So of the states, so we've already covered here, right? The state's objections to the defendant's motions to suppress. We already covered those. So then now we've got all the subsequent replies, right? The defense replies to the state's objections. Of all of those, there's 2 that we're going to go over because some of them are sealed, and then others don't really contain any information. They're just like blah, blah, right? But there's 2 that I found particularly interesting, and that's what we're going to look. That's the 2 of the replies. That's what we're going to look at. There's tons, no, you can't see. I've got a bunch of tabs, but that's what we're going to start with because we're going in like chronological order. So, okay, so this is the reply to the state's objection to the motion to suppress regarding the Pennsylvania search warrant 119 Lamsden Drive. Okay, so love that they're starting with something that they can agree on, right? First, it appears that the parties are in agreement on much of what law applies to the search of the home. Several topics Mr. Kohberger addresses are more fully developed elsewhere, and his replies to those will be filed in his other replies, i.e. Frank's, IGG, and then so on and so forth. That leaves the issue of how federal and Pennsylvania law enforcement conducted their raid. The state tries to draw out its fact section by restating things several ways on pages 6 and 7 of its objection, but it basically just boils down to, quote, we knew he was in there and owned a gun, end quote, which of course is true of most Americans. Well, I don't know. Do most Americans own guns? Anyway, the state cites to not a single case similar to the facts here. Instead, the state relies on a memorandum written by Police Sergeant Lang of the Pennsylvania State Police, apparently to justify their actions. This odd document, never before disclosed, appears to have been written in response to Mr. Kohberger's briefing and includes no date. Basically, the police tell us they had to destroy the house to save the car, or some other evidence from Mr. Kohberger's rubber gloves. No legal authority is provided. However, given that this statement now exists, the court can compare the scenario with any number of cases. So they're like, they didn't provide this before, but now that they have, here's the case law, right? The applicable case law. So here, the police were concerned about making a hasty knock and announce, which apparently meant no knock and yelling from their bear cat, because Mr. Kohberger was wearing the same gloves millions of homeowners wear to do the dishes. Two more things of note. According to the police, they had snipers watching Mr. Kohberger go from room to room, obviously greatly reducing his chances of posing much of a threat. And although the state oddly claims it is not true, the FBI had been surveilling Mr. Kohberger since December 21st and had many occasions to take him into custody. The state had identified, now this is where it gets really interesting. Oh my gosh. Okay. You guys ready? The state had identified Mr. Kohberger on December 19th through IGG. So that's going to come up because, again, I've got these presentations of all the stuff we've been talking about on these previous live streams. And really, it's the question that everybody has, including Ann Taylor, right? How did they get his name? How did they reach him? How did they get to Bryan Kohberger? You know, and it's like the two things. It's like, well, is it the Elantra? Is it the IGG? And of course, then there's the separate discussion. Was the IGG even actually done? And then there's, you know, additionally, like the state saying they didn't use IGG, but like, you know, again, as we've talked about on this channel, they basically reference it a million times over. Like when you look at even the state's objection from last June, I believe, the motion for protective order, rather. But everything else, right? It's like even the affidavit, right? It's like, it's the plausible deniability thing, right? They didn't use the letters IGG, but they referenced it, right? So, and the thing is if it wasn't that, right? If it wasn't IGG, then it had to have been the car, right? So we're going to take a look at all that. But anyway, but look at this though. So this is the first time we've been given this date from anybody yet in this case. This is news to us because as we know, all these, you know, they've had the closed hearings, all the stuff about the IG, it's all been sealed. And so we have like so little information, right? So here, the defense is disclosing something that's important that is news to us, which is that the date here on December 19th through IGG. So that's going to come up again. Okay. So the state had obtained aerial photographs of the Kohberger residence on December 21st, driven by the residence on December 23rd, followed him on December 24th. Cameras were placed on his parents' property on December 25th, and trash was taken, dad trash, December 27th. The state seems to accept that a failure to abide by laws to knocking and announcing leads to the exclusion of what was found in Mr. Kohberger's parents' home. The court must suppress this evidence. Okay, next. Okay, so the reply to the state's objection. So this is the pen, trap, and trace. Now, the reply for the first AT&T warrant is pretty much, in terms of what we're going to see here with these exhibits, is pretty much identical to this, and the argument is the same, but this one has actually more supportive like exhibits here. So instead of covering both because it would be redundant, we're going to do this. We're going to do just this one, right? So this is essentially the second ATT warrant. Remember, they were the same day, like very little time apart. What was it? A couple hours, something like that. Okay. So the words proof upon oath are not synonymous with, quote, the affidavit for search warrant and its exhibits are hereby incorporated. A non-particularized, let me zoom in more here. Okay, a non-particularized, particularized general affidavit in support of a search warrant held in the hands of law enforcement, which never accompanied the electronically served warrant, cannot be relied upon to validate warrant. So this is a different, this is, for both this one and the first AT&T warrant, this is a different issue that wasn't raised by the defense the first time around, but of course, this is a reply, right? So, okay, so the AT&T trap and trace or AT&T 2, again, this is going to be the same for AT&T 1, that's why we're not covering it. Warrant was general and the affidavit was not incorporated into the warrant or served with warrant. So the part about being general, we heard that before, but this is the new part, that the affidavit was not incorporated into the warrant. Okay, the Fourth Amendment, we're not going to read all that. We know about that. So the Idaho Constitution is virtually identical to the Fourth Amendment, except that oath or affirmation is termed affidavit. The Supreme Court has acknowledged that a court may construe a warrant with reference to a supporting application or affidavit if the warrant uses appropriate words of incorporation and if the supporting document accompanies the warrant. So in other words, you can't just have the warrant, you have to have the affidavit with it. Okay. In case law, the warrants contained no language that the affidavit was incorporated. In misguided fashion, the state asserts that there is no requirement for specific language and relies on Adam Schick v. State, which upheld a warrant where the opening paragraph of the warrant ambiguously referenced the affidavit and sworn testimony of Detective Sellers as the basis for the warrant. So they're citing this case law here. In this case, no such words exist in the warrant. The affidavit nor any of its exhibits were incorporated. So this seems like this is the problem, right? On page 3, in reference to the installation of a pen register and or trap and trace device, there's language that states, the court finds that Brett Payne, investigating officer, and Ashley Jennings has certified to the court that the information likely to be obtained by such installation and use is relevant to an ongoing criminal investigation. While this language is unique to the trap and trace warrant, it does not incorporate the search warrant affidavit or any of its attachments. Okay. The search warrant affidavit did not accompany the service of the warrant. The state, in its objection, attached the search warrant affidavit, its exhibit, and the order to install the trap and trace device. It did not attach the documents that provide clarity that the search warrant affidavit was not included with the service of the search warrant. Those documents are therefore included in this filing as attachments. Where a supporting affidavit does not accompany the search warrant at the time of the execution, the detail set out in the affidavit does not cure any deficiencies. An affidavit is considered to be part of a warrant and therefore potential curative of any defects only if one, the warrant expressly incorporated the affidavit by reference, and 2, the affidavit either is attached physically to the warrant or at least accompanies the warrant while agents execute the search. The affidavit of Corporal Brett Payne swears that the warrant was served on 12/23/2022 by sending to FBI for service. An FBI form similarly reflects that a prospective location tracking search warrant that included a pen register for this telephone number on behalf of Moscow PD was served on December 23rd, 2022. On or about December 23rd, an AT&T mobility carrier request form was completed. Attached to the AT&T form is the pen, trap, and trace search warrant at issue. The affidavit in support of search warrant was not included. The return documents, the FBI form, and the AT&T form do not reference the affidavit in support of search warrant as having accompanied the pen, trap, and trace search warrant. Again, all of this is exactly the same as what they said for the first AT&T warrant. Same problems. The process described by the state as meeting the criteria of State v. Teal simply does not exist. In its incorporated objection to the motion to suppress Apple warrant, the state indicates that the investigators necessarily had copies of the affidavit in their possession when they executed the warrant by emailing it to Apple. Further, the state offers that, so what they're saying is they're differentiating the search warrants for the both AT&T warrants. They're differentiating that from those of Apple by saying that in the state's objection, the state, at least as it pertains to Apple, the state indicated this, right? The investigators had the copies in their possession. Further, the state offers that the effect of this is that the affidavit for search warrant in appended Exhibit A cure any supposed deficiencies in the naked warrant. An officer sitting at a computer executing a search warrant by submitting electronically to AT&T and having the affidavit for search warrant in his hand is different than an officer being physically present when executing a search warrant and having the affidavit for search warrant available for reference. Okay, the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material. Again, that's the standard for Franks, right? So we've covered that ad nauseum, but just to repeat that. So in response to the state's arguments, under defendant has not demonstrated the search warrant affidavits contain intentionally or recklessly false statements or omissions, defendant refers the court to and hereby incorporates the defendant's reply, and they're referencing the Franks hearing there, right? And the motion to suppress IGG. So of course we don't have that. And then there's the conclusion. So the rest of this is going to be these attachments that they were referencing here. So we have to see, right? Did they incorporate the affidavit? And so this is these are unredacted. So I, Corporal Brett Payne, the officer by whom this warrant was executed, do certify the appended inventory contains a true and detailed account of all property taken by me or other officers pursuant to the warrant. There's the affidavit of Lawrence Mallory. Contained a search warrant, blah, blah. So what we're looking for, though, is the affidavit, right? So here's the receipt, an inventory of warrant. Entrance was obtained by sending to the FBI for service, as FBI hosted the pen register and precision location. Okay. Still no affidavit, right? Okay, so let's read this. So this is in the matter of the application for a search warrant for AT&T. So in the above titled manner, this court having heretofore issued a search warrant and the said search warrant having been served according to law and the return of warrant having been duly made as directed in the said search warrant to this court, and a written inventory of the property found and seized having been duly made and taken before the undersigned magistrate or judge and filed herein. Now, therefore, it is hereby ordered that the said peace officer shall deliver or cause to be delivered the property described in said inventory to the Moscow Police Department or such other law enforcement agency as may be appropriate for the purpose of preserving said property for use as evidence or until further order of a court of competent jurisdiction once any related criminal case has been concluded, including the expiration of time for appeal, or at such other appropriate time the property can be released. So it's like he could get his phone back, right? Okay, so this is signed by Megan Marshall. So this was the magistrate judge who signed off on these warrants. Now remember, as it pertains to the Franks hearing, part of the whole thing is it's like they represented to the magistrate judge, Megan Marshall in this case, right? That this is what they say it is, right? And so that matters, right? In terms of making knowingly false or reckless or just with a disregard for the truth or omitting things, right? And so therefore it's like the judge signed off on it, but it's not the judge's fault because they were misled by law enforcement, right? And that's the whole thing. So, okay. From the FBI. All right. On December 23rd, 2022, the FBI served a prospective location tracking search warrant that included a pen register on behalf of the Moscow Police Department. The information captured as part of this legal process is being attached to the 1A section of this serial. Okay, so there it is. So there's that name Ballance, right? So this is, again, remember when I said I'm wondering the mystery people that have been subpoenaed, right? That will come and testify, or else basically at the hearings on the 23rd and 24th. This is the Ballance. And I was wondering how they spell it. So it's 2 L's, but yeah, that's Agent Ballance. Okay. So there you go. He's, I would imagine, I mean, we got to hear from him, right? And Imel. So, okay, here's the request form, billing address to the FBI. So far, no affidavit, right? Okay, here's the search warrant and order authorizing the installation of the pen, trap, and trace. All right, so here's the thing that I guess the state is saying is sufficient, right? Brett Payne, having given me proof upon oath, this day showing probable cause, establishing grounds for issuing a search warrant and probable cause to believe there are records related to the crimes at 1122 King Road and are currently under the control of AT&T, blah, blah, to include. And then this is what they're obtaining, right? So subscriber or registration account information, including the name or identity, address, billing, payment information, account initiation date, custom account features, blah, blah. Device identifying information. So MAC address, IP address, usage and location information, including stored and transactional records, all SMS and data connections, calls, GPS. I mean, it's literally fucking everything. Cell site positioning information, physical address of cellular antenna towers used by the customer's device, subscriber identity information for customers who contact or are contacted by the device using the target address located at the following premises. So I guess that's the premises there. So you are therefore commanded to search the above described premises for the property described above, to seize it, blah, blah, blah. Further, there is probable cause to believe that the use of a pen register and trap or trace device will lead to law enforcement acquisition of real-time information, and that it will be evidence related to the crimes. The court finds that Brett Payne, investigating officer, and Ashley Jennings has certified the court that the information likely to be obtained by such installation and use is relevant to an ongoing criminal investigation. Again, this was referenced earlier in this document by the defense, but that is not enough. That is not the affidavit, right? Pursuant to I.C. blah, the court finds the identity of the person to whom the phone is leased or in whose name is listed to the telephone line to which the pen, register, or trap and trace device is to be attached as Bryan Kohberger, and the identity of the person who is subject of the criminal investigation is also Bryan Kohberger, and the phone number, physical location of the phone is currently in Pennsylvania. Service provider. It is hereby ordered that the above identified investigative agencies are authorized to install, that was the FBI, and do all this shit, gather all the shit. It's further ordered that the above identified investigators and investigative agencies are authorized. Okay, so yeah, again, they can do all the stuff. It's further ordered based upon probable cause that the above identified service provider, investigators, investigative agencies are authorized to use a cell site simulator in connection with the target address. GPS. It is further ordered that for the purposes of this order, the terms cell site simulator and cell site simulator data include pen register and trap and trace and all the data that they get from that. Make sure they have all the stuff they need to fulfill this. Okay, so it is further ordered that investigators and service providers are authorized to continue using the tools and techniques authorized by this order during any time that the devices are being monitored, enter private property, and that they can take any steps necessary to limit collection of any information or metadata to the target address. take all steps necessary to permanently delete it. And there you go. There's the time that to be completed no later than February 23rd. This order will be sealed until otherwise ordered by the court. So that happened. And until then, just only the legal counsel and whatnot can have access. Okay, so there, and then again, Megan Marshall. And so this was signed. There you go, 20, and we have this time. We knew this time already, but 4:53 p.m. on December 23rd. Okay, so clearly, the affidavit was not incorporated because we just looked. I mean, that's everything. So okay. So we'll see. They will argue about that on either the 23rd or the 24th. Okay, so now okay. So this is where things get really spicy because this is the first, as it says in the thumbnail, first motion for sanctions so far in this case. The first motion for sanctions. Okay. So this is a defense motion, right? Motion to compel. Immaterial for sanctions. So, okay, request sanctions pursuant to I.C.R. 16K. All right, the bulk of the state's expert disclosures fail to include opinions and reports. These inadequate disclosures greatly prejudiced Mr. Kohberger, who is obligated to submit defense guilt phase expert disclosures by January 23rd. And if that date sounds familiar, of course, it's because that's also the date of the motion to suppress hearings. The sanctions considered must be the exclusion of the experts or, at a bare minimum, an order compelling proper disclosure and an extension of Mr. Kohberger's deadline. So the sanctions considered, right? So I would say excluding their witnesses would definitely be a sanction. But I would say that an order compelling proper disclosure and extending their deadline, that wouldn't be that's more like the standard remedy, right? Like, so okay. So if you're thinking about, okay, so what they've said so far, right? The state has not disclosed their experts with opinions and reports, right? So usually what happens in that situation? Well, they complain about it, and then the judge makes an order and says, turn it over, right? I mean, that's what normally happens, right? It's like, come on, we've already seen this a million times in this case. So the difference here, so it's interesting because it's like, what's with the sanctions then, right? That was the question I asked myself, because it's like, why is it that they think that this is sanctionable in terms of excluding the witnesses altogether? Right? Because think about it, right? Like if you're just behind on a deadline or whatever, again, this has been happening this entire time, at least in the defense's perspective, where, they're not turning stuff over. They're like, well, we can't turn it over because we don't have it. And then it's like this whole thing, right? But the defense views this differently because they're requesting, a severe sanction here. Or alternatively, at a bare minimum, make them disclose it and extend their deadline. Of course, that seems more reasonable. But the real question here to me is like, so then what's the deal with the sanctions, right? Because that's a big deal. That to me, right off the bat, implies that the defense sees this as not just being negligent or being shady or being lazy or being disorganized. This to me, the fact that they're asking for this, right, when they haven't before, to me means that the defense thinks that this is more intentional, right? More, more like malicious, if you will, but more intentional. That this isn't just, they just haven't turned it over, right? That there's something else behind it. So we'll see what else is in this filing here, and it might give us some insight. Okay. So Mr. Kohberger is prejudiced because he does not know what expert evidence the state intends to elicit. He does not know what expert evidence he must confront. Yeah, I mean, obviously, it goes without saying, right? It's like, to me, it's like, this is a no-brainer, right? Like, you have to turn this shit over. But the reason that they are having to, it's like, why would you have to state the obvious, right? And in this case right here, it's because, again, they're asking for sanctions. So, relevant facts. In this case, there are over 68 terabytes of discovery produced in a method that the defense has repeatedly referenced in pleadings and at various motion hearings as extremely disorganized. There have been 20 requests for discovery and 6 motions to compel filed by the defense. Their previous order there notified the parties that strict compliance with the court's order is expected. On December 18th, the state disclosed 25 experts. Of those, only 5 include actual expert reports. So that means that they're missing 20 expert reports, okay? Notably, not a single DNA expert opinion or report was produced. That is interesting. No wonder they said notably, right? Instead, the state's, oh my God, no, don't be annoying. Instead, the state's disclosures refer to Bates numbered pages and say, quote, this disclosure is provided as an aid. It does not encompass all findings, impressions, conclusion, or materials related to this expert's involvement in this case. It further does not in any way limit the scope of the expert's testimony. This is crazy. Further, this expert may testify about findings, impressions, and or conclusions that he or she drew from the work of other experts who previously examined or handled the evidence in question, end quote. So not only are they not disclosing the expert opinions, and in 20 out of the 25 experts, are they also not turning over a report? Not only that, but they're actually saying, the state's actually saying, like, basically, they can testify to basically whatever the fuck they want at trial and don't need, like, this is insane. Insane. Hi, Candace. Glad you're here. How are you doing since you're a California squirrel? Are you being impacted by the fires? Are you safe? Like, this is insane. Let me zoom in. So no report, no expert opinion, and instead they say, this disclosure, so it's just a disclosure, as in, here's an expert witness, right? This disclosure is provided as an aid. It does not encompass all findings, impressions, conclusion, or materials related to this expert's involvement in this case. It further does not in any way limit the scope of the expert's testimony. Now, this is the most insane part of all to me here, because that's the whole point. I mean, we've seen this in other cases. Recently, Sarah Boone is a great example, right? Remember the Richardson hearing? Because you can't have an expert make an I mean, it happens in other trials. It's just a recent example, right? You can't have them offering a new opinion. I mean, we've seen this as well in Casey Anthony. I mean, they cannot testify beyond their expert disclosure. That's the whole fucking point. So this is saying the opposite. Like, what the fuck? Further, this expert may testify about findings, impressions, and or conclusions that he or she drew from the work of other experts. So now, they not only is their opinion not limited at all, not that they're even disclosing it in the first place, but they may also opine on the work of other experts. Like, this is insane. So other experts who previously examined or handled the evidence in question, end quote. At least 3 digital forensic experts are disclosed with lists of 67 electronic devices or third-party databases examined. Not a single report of what the experts will opine it's related to any specific evidence or data is disclosed. So, you can, are you guys seeing now why the sanctions? Because it's like, this is not a mistake. Like, this is I understand it, because it seems like this can only be willful, right? Like, you have to disclose it. Like, this is 101. This is like to not disclose the expert opinions or reports is insane. So you can see why they're asking for sanctions, because in other words, it's like the state is doing this on purpose. This is like a strategy. There's a reason they're not disclosing it, because they know they're supposed to, right? And so that's why they're asking for that extreme sanction of saying, exclude these witnesses, right? So Candace saying that she's good. One of the kids was evacuated. Okay. Wow. How far are you from LA County, if you can remind me again, Candace? I'm glad that you're okay and that your kids are safe. Okay, argument. I mean, again, it's like this all seems like, does this really need to be said? No. But again, because they're asking for this extreme sanction. This is a capital murder case and nothing about it is clear cut. The expert issues are complex, involving many different facets of DNA, cellular data, cell tower coverage, and drive testing, car identification, crime scene and blood spatter analysis, fingerprint analysis, forensic pathology, and electronic device analysis of the suspect, victims, and alternative suspects, and social media accounts. Now, also there's a footnote here. Where is that? Okay. Oh, about the deadline. Right. They're seeking to extend the deadline. That's in a separate filing. Okay. At issue is the state's supplemental response to request for discovery regarding expert testimony and its exhibits filed December 18th. The disclosure lists 25 experts and provides curricula vitae, 5 with expert opinion reports, and others with reference to its number of pages or items, but no opinion data or methodology. What the state's disclosure does not do is follow the rule which states. So here is the rule. In other words, this is the rule that the state has to follow. Let's read this. Expert witnesses. On written request of the defendant, the prosecutor must provide, not may, must provide a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rules 702, 703, 705 of the Idaho Rules of Evidence. The summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness qualifications. So in other words, they provided the qualifications and that's it. Disclosure of expert opinions regarding mental health must also comply with the requirements. The prosecution is not required to produce any materials not subject to disclosure under subsection of the rule. The subsection does not require disclosure of expert witnesses, their opinions, the facts and data for those opinions, or the witnesses' qualifications intended only to rebut evidence or theories that have not been disclosed under this. So here's what this is saying. There's a separate rule, right, for when it pertains to rebuttal expert witnesses. So, we don't always see a rebuttal case. We saw it in like Murdoch as an example, right, where you have, the prosecution has their case in chief, and then the defense has their case in chief, and then rarely, again, it doesn't happen that often, but they're allowed to, right? The state can have a rebuttal. And so, in other words, if it's expert witnesses in rebuttal, okay, this does not apply to that. That would be a separate rule. Okay. But if it's for the regular case in chief, right? If we're in the guilt phase case in chief, then, if it's their case, the state's case, then they have to follow this rule. So this will get even more interesting here. So 60 miles. Okay. So that's like what, 2 hours or so drive? I hope your air quality is not too terrible. I would imagine it's probably pretty bad though. As the Court of Appeals has held, the plain text of Rule 16b-7 requires the disclosure of expert witness opinions, the facts and data, and also any testimony, right? We just read all this. That encompasses not only an expert's opinion, but also scientific, technical, or other specialized knowledge to which a qualified witness may testify in a form other than an opinion. Shout out to Black Witter. Hello, my friend. As the court explained in Warren, when an expert relies on some form of scientific or technical information that must be disclosed, as opposed to other witnesses whose opinions may be of the less scientific variety, the discovery rules are designed to safeguard the truth-seeking functions of trials, promote fairness and candor, to facilitate fair and expedited pretrial fact-gathering, and to prevent surprise at trial. Surprise! Similarly, speaking of surprise, a Poot Surprise. Imagine if they had a Poot Surprise at the trial. Okay. And there's an exhibit A being filed under seal. If the state violates a disclosure requirement, here we go, right? Here's where the sanctions come in. If the state violates a disclosure requirement under I.C.R. 16b-6, the trial court has considerable discretion to fashion an appropriate remedy. Mr. Kohberger continues wading through a sea of discovery, like a mermaid. The need for rule compliant expert disclosures is critical to his ability to prepare for his defense at trial. The state's failure to comply is not harmless. So Mr. Kohberger must be able to confront the evidence against him, and to do that, it must be disclosed in accordance with Idaho Rule 16 and this court's trial setting order. This expert disclosure, the expert evidence disclosed by the state is woefully inadequate. This is a capital murder case, and compliance with the rules of discovery are not optional. Mr. Kohberger is prejudiced by the state's failure. It is impossible for him to confront unknown expert opinions with his own expert disclosures by January 23rd. And so they have this approaching deadline. Okay, so now, of course, the state's going to object. What's the state going to say for themselves, guys? What is the state going to say for themselves? So given what we've read so far, it makes one wonder, are they going to say, oh my gosh, I don't know how this happened, blah, blah, or are they going to say, well, because as per the rule, right? Remember, it doesn't apply for rebuttal witnesses. So are they going to just say, well, actually, so again, they have 25 expert witnesses. Five of them have reports. 20 of them don't have reports, and none of them have opinions. So I don't even know how they would make it work, but the best they could do, I would imagine, I haven't read this yet, right, is like, oh, well, 20 of those expert witnesses are for rebuttal. But even if that was the case, the other 5 are still lacking opinions. But anyway, so let's see what they say. Because in other words, the only way around it is to be like, oh, they're rebuttal expert witnesses. But like, are you saying you're going to present 25 expert witnesses in rebuttal and then none during your case in chief? Like, yeah, okay, Santa. Yeah, Blackwater asking a good question for Candace. Do they have federal or state help? If she knows. Oh, I don't know. Well, was I early? Maybe I was early. I don't know. But yeah, glad you're here. I'm just looking at the title. Am I in the right? Yeah, I'm in the right stream because I have so many streams set up. Sometimes it's easy to click the wrong one. I'm in the right stream. Okay. So, we're still getting snow here, I do believe. By the way, for any of you guys who are in the Discord, I put a funny meme thing there related to the Adelson case. If you guys want to check it out, it has to do with Trescott. I was inspired by DSN. It's pretty funny. Okay, so all right, so what is the state going to say for themselves? State's objection. Relevant facts. The state has been actively engaged in replying to the defendant's request for a discovery. I love how they act like this is a burden of theirs, like actively engaged, like this is so annoying, blah. It's like, this is your job. Like, you can't complain when they ask for discovery. It is your job to turn over discovery. That is how this works in a criminal trial. You obtain the discovery because you brought the charges and you provide it. If you don't feel like providing discovery, don't bring the charges, okay? Ugh. Okay. Including materials related to potential expert witnesses. So you see they're saying, no, we did it. For fuck's sake. Since the original discovery request was filed on January 10th. As I.C.R. 16J, so they're citing a different subsection of Rule 16, contemplates discovery involves a continuous, a continuous duty to disclose. So, it's interesting, right? Before I read on, like, you guys, how do you think this is meant? Like, how did Idaho mean this when they said there's a continuous duty to disclose? Does that mean, do you guys interpret that as meaning, well, you don't, like, if you haven't turned something over already, it's because it's a continuous duty? Like, in other words, I wonder, is Santa going to try to suggest this means procrastination is okay, right? Because there's a continuous duty, you can just procrastinate. I don't think that's how that's meant. I don't think that's what they're saying. Yeah. I think what they're saying is it doesn't end. Like, if you get more discovery, you have to turn it over. Anyway, which the state has and will continue to comply with. This specific continuing duty to disclose evidences that I.C.R. 16 compliance is not a one-time event. Aha, right? Defendant currently notes that this case involves a substantial amount of discovery. Defendant cites over 68 terabytes. The state does not dispute this. The discovery received by the state from multiple agencies has been provided to the defense in the same manner it was provided to the state. So they're saying we didn't make it disorganized. It was provided to us this way. Incredible. The state is in the same position as the defendant in this regard with a footnote. So are you like, okay. Are you this incapable though, Santa? Like, are you that incapable? It's like, okay, I guess law enforcement, they turned over all this information. It was really disorganized. Are you just like, well, I guess that's it. It is what it is. Like, are you that incapable? Can you not organize it? I swear to God. Like, what are you going to do at trial? Shout out to ABC's docket. Glad you're here. I'm trying to remember. Did we give you, did you get a command yet? Did we do a command? Did you ask for one? So I figure if there is one, it would be explanation. There it is. Sweet. Cool. Everybody's got their commands. Okay. So, this is insane. This is like, we are babies. It's like Prosecutor Santa is like, we are babies. We can't do anything. Like we're just, you know, it reminds me of Lolly. It reminds me of Lolly ever since Hank Brennan was brought on, where it's like, they're just passive. They're just like, well, we're just sitting here letting things happen. Right. We don't actually do, like, we have no control over anything. We can't do anything. Like, it's just crazy. This is crazy. Like, look at this. It's like, almost like you should feel sorry for us. Like, this is crazy. There's a footnote. What's the footnote going to say? Defendant complains and appears to represent that he has not been provided with adequate information from the state. This is patently untrue. By way of example, to appreciate the true degree of analysis and use by the defendant of discovery that has been provided, the court need look no further than the extensive detail in the defendant's motion for a Franks hearing, the 20+ supplemental discovery requests and related materials, and the many other detailed substantive motions he has filed. Okay, so what they're saying is, look, we can show you that we've turned stuff over because look, all the stuff that's in the Franks, the memo for the motion for a Franks hearing, of course, is sealed, right? But they're saying, look at all that information. Where do you think they got that information? From us. Of course, the irony though, right, is like all this information is saying like basically this entire case needs to be thrown out because it's all fruit of the poisonous tree. Anyway, not to mention that doesn't mean that it's included in everything, right? Like that doesn't. Okay. The court record will reflect that the state has provided extremely detailed responses to defendants' requests for discovery and motions to compel, and beyond what is required by Rule 16. On December 18th, the state in compliance filed its guilt phase experts consistent with, okay, what's he going to say? These disclosures were filed 7 months and 24 days before the date is not the problem, Santa. This is insane. They didn't complain about the date. They're saying you didn't give any expert opinions. What is happening? Oh my God, no. Okay. Santa, did you not read the defense filing? What is happening? There was okay. The defense did not say there was a problem with the date. The defense said the problem is you provided reports for only 5 of the 25 experts and opinions for none of them. There's more than that. That's the summary. That's the minimum of what they were saying. And then they were saying that the only date that they had an issue with was their own date of deadline because they can't respond to what they don't have. But they didn't like this is a straw man or whatever, you know, like argument here, right? They're like, what is happening? They didn't. I don't know. This is on another level to me. Am I reading this wrong? Nope. Look at this. Look at this. These disclosures were filed 7 months and 24 days before the commencement of trial. As of the date of this filing, we are at 7 months and 12 days. Like if you're sitting around counting days, maybe if you took that time and used it to organize your data that you complained about, Santa, right? We are in the same position, blah, blah, blah. Well, maybe if you, dude, Or you could use it to do all the other things you're supposed to be doing. Like, this is crazy. This is like, I know you are, but what am I? This is so stupid. Nevertheless, defendant argues that he's been prejudiced and requests sanctions. Defendant's arguments are without merit. I disagree. Argument. State has complied. No. What is happening? The only thing I think, again, what are they going to say for themselves? The only thing I could imagine would be trying to say that all of those experts are for rebuttal, but then what are they going to have? What is their case in chief going to be then? Okay, here they've included another thing here. So experts, it says a list of experts the parties intends to call at trial, including a copy of the expert's report, consistent with I.C.R. B7. Right, that means they have to include an opinion. I can't. And a copy of the curriculum vitae. Right, that's fine. Oh my God. The summary provided, so they italicized summary. This is so stupid. Look, they're like, hey, I'm going to lose my mind. The state is like, look, it says summary. And so they italicized it, emphasis added, right? There it is. You know, again, just like how the defense didn't say there was a problem with the date that they disclosed them, they also didn't say there was a problem with a summary. What they said, the state is conveniently ignoring, is this was not included. No opinions, the facts and data for the opinions. The only thing provided was the qualifications, and that's it. I cannot with this. You guys, I'm losing my mind. Okay. Whew. The defendant cites State v. Warren. And this is in regards to this particular case that they're citing for case law here. I'm not going to read all this. The court held, this is what we need. The court held a mere list of topics or general subject matter with which an expert witness may testify is not a discovery response that complies with this rule. The court also stated, even if the state did not know all the details of Dr. Dalton's testimony at the time of the initial discovery response, the rule imposes a continuing duty to supplement the response if a party later discovers or decides to use additional evidence. Yeah. We always hear about this, right? Remember how in like every trial we hear, okay, they had a supplemental report, right? An additional, more than one report. That's what they do, because when they get new evidence, they can add that. They can supplement it. I don't understand why the state, though, is citing all this as if this supports their argument. Like, what? What you're saying is okay. By way of contrast, in State v. Cock, the defendant was charged with lewd conduct with a minor. Ironic. The state filed the following expert disclosure. Okay, I'm not going to read all that. So they argued that the above disclosure was insufficient because it failed to disclose the opinions, facts, and data behind those opinions. The Idaho Supreme Court disagreed. The Supreme Court held that disclosure informed the main opinion. And it said basically that it would have been better practice to include, to disclose that the opinions were based on the training and expertise. It did provide curriculum vitae. Don't hang your hat on that. That's not the point. Opinion, the O word. Santa, dude. Okay. Further, the Idaho Supreme Court held that the state does not have to produce a written report where none had previously. Okay. Let me read this again. Further, the Idaho Supreme Court held that the state does not have to produce a written report where none had previously existed, stating if there is no data, the state doesn't have to produce data. She's simply an opinion witness. Noting that in this other case, right, the defendant could object if the testimony varied from the state's disclosed summary. Guys, what do you think about this nonsense? I don't know how I feel about this, right? Like, if there is no data, they don't have to produce data. They can just be an opinion witness. So, like, I don't even understand this. I don't understand. Maybe I should look at what the specific. Okay, so let's, in order to try to understand that, right? Let's see what, so again, this is in this other case here, right? State v. Cock. Let's actually look at the facts here regarding their expert. So Miss Yeager's curriculum vitae is attached. So again, fine, curriculum vitae. She'll testify to the dynamics of delayed disclosure as it relates to child sexual abuse. And remember, this is an expert witness for the state in this case. The state intends to elicit expert testimony from Miss Yeager regarding behavior of children who have been sexually abused, and Miss Yeager will testify that it is rare that a child immediately discloses their sexual abuse, especially when they know the perpetrator. Ms. Yeager will testify about the dynamics of sexual abuse, child sexual abuse as it relates to grooming, keeping it a secret. Okay. All right. I see what they're saying here. So back to this. If there is no data, the state doesn't have to produce data. They can just be an opinion witness. That doesn't sit right with me, because that's why I wanted to go back and read this, because even going back and reading this, y'all know there's data related to literally this opinion, right? I mean, I feel like this has a lot of overlap with other things that we hear experts testify about at trials related to abuse. Maybe it's not child sexual abuse, but, you know, in a lot of this is the same, right? In other situations of abuse, or things that are even just similar in terms of like sensitive topics where you've got an expert, maybe some sort of a psychologist or something. But anyway, my point is this: in every trial, they always produce data. There's always a report. There's always an expert opinion. They don't just get up there with nothing apart from their CV and then testify out of their mouth. Okay. Oh boy. The Idaho Supreme Court in Cock discussed the scope of I.C.R. 16b7 disclosure requirements and looked to the Federal Rule of Criminal Procedure 16A1G. That's the rule regarding expert witnesses. We've covered that in other live streams and other trials. The Supreme Court noted that the main difference is the federal rule requires. Okay, so they're saying here's a distinction from the federal rule, right? And then the Idaho Supreme Court, okay? So the federal rule requires the basis and reasons for those opinions, where the Idaho rule requires the facts and data for those opinions, suggesting the federal rule requires broader disclosure. I don't know. I mean, I will say this, right? While it does state this, it also, well, let's just pull it up. Hold on. I've got the booklet here, but you guys can't see that. So, hold on. So we're looking for 16A1G. Okay. Okay, here we go. Here we go. So letter G. Let's see, what is the state omitting, right? What's the state omitting? Because they're omitting. What are they omitting specifically, though, from their objection? At the defendant's request, the government must disclose to the defendant in writing the information required for any testimony that the government intends to use at trial or during its rebuttal or to counter testimony. Now, again, this looks like that was different in the Idaho rule, but whatever. If the government requests discovery under the second, okay, that part's not applicable here. Here we go. The disclosure for each expert witness must contain a complete statement of all opinions that the government will elicit from the witness. Opinions, oh word. Complete statement of all opinions that the government will elicit from the witness in its case in chief or during its rebuttal to counter testimony that the defendant has timely disclosed. The basis and reasons for them. The qualifications, obviously, other cases that they've testified in. Okay, so going back to this, he's not wrong that it does say basis and reasons, right? Again, when the question I just asked, what is the state leaving out? The state left out. Okay, Conveniently this. A complete statement of all opinions. I cannot. I can't. Again, it's focusing on things that are not the issue, right? Initially, it was focusing on the date. The defense had no problem with the date you disclosed them. Then it's focusing on blah, blah. And now it's like, dude, I can't. It's not addressing the actual problem yet. We'll see. The Idaho Supreme Court further noted that the expert's conclusions were adequately explored by defense counsel on cross-examination with no particular difficulty, evidencing that the state's disclosure was adequate. Well, I don't like that either because the goal of Rule 16 is to provide the opponent with a fair opportunity to test the merit of the expert's testimony through focused cross-examination. Well, not just that, though, right? As stated in the rule itself, the goal is also so they can provide appropriate expert witnesses to rebut that in their case. Wow. Okay. So here's another case here. I can't. Again, conveniently omitting the part about the opinions, right? So in this case that the state is citing here, they're like, the state did not provide the papers and graphs on which the conclusions were based. Fine. Until requested at trial. I mean, not that that's okay, in my opinion. However, again, this is not on point. They need to find, dude, I'm going to lose my, the state needs to find, and they won't be able to, right? A single case where they say they did not provide the expert opinions, period. If they can provide that, I will fall over in shock, but fine. But that's not what they're doing. They're finding every other little thing. Turning to the case at hand, the state disclosed, so this is this case, right? 25 potential experts. The state, okay, now there's a footnote. In an abundance of caution, the state included witnesses that the state does not label as technically experts. But anticipates the defendant might disagree. All right, what does this mean? So they're trying to make another excuse here, I believe, my opinion, that they're saying, well, the state doesn't technically label them as experts. Now, why would they be saying that? To try to say, well, they don't have to then disclose, they don't have to follow the rule, right? The rule is for experts. However, they anticipate that the defendant might disagree. So therefore, out of an abundance of caution, they included them as, they labeled them as experts. Okay, fine. So I don't care who if it's because, you know, it came to you in a dream that they should be expert. It doesn't matter what the reason. If you're labeling them as expert witnesses, you have to follow the rule. So stupid, pointless. I can't. This whole thing of like the state trying to be like, look, we've gone above and beyond, or poor us. This is so silly. The defendant takes issue with 22 of the disclosures, claiming they are insufficient. All 25 of the state's disclosures comply with the court's order, not according to the defense, and I.C.R. 16b7, and are not the generic discovery response. All 25 disclosures encompass more than a mere list of topics or general subject matter. Each disclosure informs defendant of the main opinion, but the rule says it has to be their entire opinion, because if they have additional opinions thereafter, they have to file a supplemental report. I'm going to lose it. To which each expert will testify in the CV, which that opinion is based on. The CV, again, they keep referencing that. Why? Because they turned over the CVs. The defense didn't complain about that. The defense didn't say there was a problem with the CVs. For experts, the problem is the reports and the opinions, right? For experts where the state does not have a report, as further held by COP, if there is no data, the state doesn't have to produce data. Again, of course, they're relying on this. Remember, I was like, this is iffy. I don't really agree. Even in the example, we went through and looked at those facts. I was like, we've seen. The state addresses each objection to those proposed disclosures as follows. For exhibits S1 through S1 through and S6, the state disclosed expert opinions regarding the toxicology results for all decedents and detailed and provided toxicology reports. In addition, the state included the CV. Who gives a shit? This disclosure was not merely a topic list of general subject matter which the expert may testify. Instead, it is the main opinion. Main opinion does not sound like the whole thing, Santa. And the CV. I'm going to lose my mind if he references the CV again. As noted by the Court, the Idaho rule, so they're really relying on that one case, which in my opinion, I don't agree with. The Idaho rule is not as broad as the federal rule, which requires the basis and reasons for those opinions. Yeah, you know what? You don't have to provide if you don't even provide the opinion at all. It doesn't even matter. Like, this is all a moot point if you didn't even provide the opinion in the first place. Anyway, whereas the Idaho rule requires the facts and data for those opinions, right? I swear to God. Oh, here we go with Agent Ballance. For Exhibit S2, the state disclosed Special Agent Ballance. Oh boy. The state's disclosure was adequately specific. It states, S.A. Ballance will provide his opinion, oh boy, as the general locations in which the target cellular telephones were located at various times before and after the homicides at 1122 King Road and the cellular phone's direction of travel. That's not an opinion. Are you joking me? That is not an opinion. Look. Provide his opinion. That's not an opinion. The opinion would be, what does this mean, right? Stating the date. This is the date. This sounds like the data, although general locations doesn't sound good enough to me, but whatever. This sounds like the data, right? Opinion would be, what does the data mean? So what's happening here is the state is presenting what looks like it would be data, but they're calling it an opinion. I swear. The attached report detailed the target cellular phones analyzed, the dates analyzed. Again, none of that's an opinion. In addition, the defense was directed to the cell phone records provided by AT&T and the drive testing files which support the report. Where's the opinion, though? The defendant appears to be requiring compliance with the federal standard. No, that's not it. Oh my God. The state's disclosure provides defendant with adequate notice of no. Oh my God. I hope, dude. I know, right? I agree, Candace. I agree. Wouldn't it be easier to just provide the opinion? Like, this is insane. Like, what are they doing? What? Like, what? Either they're going to have to turn it over anyway, and they're going to get yelled at by the judge, hopefully, or that's the best case scenario for the state. Because remember, the sanctions here that the defense is asking for is to exclude these expert witnesses, right? Excluding them entirely. But you can't just not turn it over. So what are you stalling for? Like, that's what's so crazy, right? And I guess that you know, as I say that, it's like, oh, right, because the defense has a deadline of January 23rd, right? So that's where you can see, again, like I mentioned earlier, why does the defense see that this is sanctionable? Because again, this puts them in a huge problem when they've got this deadline where they have to disclose their experts, but that they can't do that until they get this shit from the state. Oh my God. Okay, for exhibits S5 and S7, the state disclosed 2 likely fact witnesses as experts out of an abundance of caution and was clear about this intent. The defendant's argument that the state erred in this good faith disclosure is without merit. In the event either of these witnesses are in fact experts within the meaning of I.C.R. 16b7, it is clear from each disclosure exactly what these witnesses will testify to based on the provide. No, not good enough. That's not what. A fact witness is different. A fact witness is like, I did this thing at this time, like, for example, chain of custody, right? I collected this thing and I sent it here. They don't give an opinion. They're just a fact. Like, so this is really crazy. So now they're trying to, like, look at all the different ways they're trying to weasel out of this, because it's like every excuse in the book, right? So now it's like, oh, okay, maybe these are really just fact witnesses. And so they don't need to have an opinion, but you label them as experts. Fact expert is not a thing. An expert witness is someone who gives an opinion. That's the whole point. Oh, and now we have Agent Imel. For Exhibit S8, the state disclosed the vehicle identification expert, S.A. Imel. I'm excited to hear from him. The disclosure specifies he will testify to his use of the forensic audio, video, and image analysis program. Remember, he's the one who decided what year the car was from, and then, according to the state, changed it, right? But we don't know when. We'll get into that. The program was used to determine the make, model, and year of a suspected vehicle. So what they're saying is there was a program. Look, it's in italics here. A program was used. So in other words, they're going to say it wasn't his opinion about what year the car was from. It was simply a computer program. He just punched in the numbers and the computer spat out the answer. Now, interestingly, if that was the case, why did the program change its mind about the years, right? Normally, you would think, if anything, it would get more specific. It would start broader. Like, if anything, you would think it would start with 2011 to 2016, although that is so broad that still blows my mind. But you would think if they're going to start somewhere, it would start broad and then get narrow versus the other way around. But regardless, it seems I can't picture how a computer program would change its mind given the same data, right? And give a different result. It's like if you had a calculator and you do 2 + 2 and it gives you 4 every time, and then all of a sudden you do 2 + 2 and it gives you 17. It's like, how did that happen? It's clear from the disclosure that this witness is an expert in vehicle identification. Defendant has repeatedly been provided the images relied upon. The state's disclosure provides defendant with adequate notice of Special Agent Imel's anticipated testimony to satisfy. Look, this is insane. If you want him to be considered an expert, because as we know, there are advantages to making someone an expert witness. If they're going to be an expert, that means that they're going to give an opinion. You have to provide the opinion. End of story. This is stupid. What are they doing? Okay, for Exhibit S9, the state disclosed Kathy Mabut, the Latah County coroner. Oh boy. The state detailed each opinion to be proffered. The opinions were supported by the attached death certificates authored by the coroner and the coroner CV. The defendant fails to mention that in addition to being an attorney and elected coroner, Ms. Mabut was a registered nurse. What? Oh, okay. So some of this, okay, remember, because this deals with some of this is sealed. That's why we don't know what they're referencing here. Like, in other words, I was like, where is this coming from? This part here where it says the defendant fails to mention that, because we haven't seen this document. That's why we haven't seen this. So they're referencing something that happened that we haven't seen. I guess what this looks like to me is that the defense, there was some talk about this coroner, Ms. Mabut, and I guess maybe the defense was challenging her qualifications, potentially, just trying to read between the lines here. And the state is saying, well, when they did that, they didn't mention that she's also been a nurse for 44 years or something. So, but also it's really weird because usually you don't qualify whoever does okay. So this coroner, the opinions were supported by the attached death certificates. Okay, but did you say what the opinions are? You can't just say, here's the death certificate, and that's going to support the opinion, but not give the opinion. You have to give the opinion. It says they specifically detail each opinion to be proffered. So this would not be, okay. So my thought here is it looks like they're going to have a forensic pathologist, right? And this coroner. Like this coroner, it varies by the state. We've covered this a lot with coroner versus ME and forensic pathologist. But a coroner can't do an autopsy, okay? So in jurisdictions where they don't have a medical examiner. Now, medical examiner is a forensic pathologist that is employed by the government, right? So they work for the government. So they are a forensic pathologist that's hired by the government. So in jurisdictions, for example, like with Murdoch, right? They don't have a medical examiner. They have a coroner. So whenever they have to do an autopsy, they hire, right, a forensic pathologist from a nearby esteemed medical, hospital or whatever. where so in other words, a forensic pathologist, it's not a medical examiner. They usually are going to be in the hospital doing autopsies in the hospital, right? But in a situation like that, where they don't have an ME, then the government then would hire them to perform autopsies for the government, right? For example, Dr. Ellen Reamer, right? She's a forensic pathologist. And so that's who they use when they need an autopsy. So this is interesting to me, because why are they using opinions from the coroner then, right? Because like, as we learned, the coroners are really just like, how can we say this? They're just like a, what's the word I'm looking for? They're a remnant of of tradition. Like, you know, sort of like the king and the queen of England, right? Where it's just like, it's, you know, they're an elected official. They don't have to have any medical training. They don't have to have, there's like no requirements at all, right? We've covered this at length with Murdoch, but they don't actually do anything. I mean, most of the time, right? They don't, because again, they don't have any like they don't do autopsies, you know. Remember coroner armpits from Murdoch, if you guys saw that. So so it's interesting that that's who the state would choose to disclose as an expert witness. Again, I'm hoping there's got to be a forensic pathologist. And the reason I say that is because in places where there is a coroner, from what I recall from when we went through all that, places you won't have both. You won't have both a coroner and an ME, because both are there in terms of the government official, right, or position. You'd have one or the other. So if you have a coroner, then there would be you know, you could say like a third party, right? Forensic pathologist, as in they aren't an employee of the government. They're just brought in like a contract, you know, or what's the word? Independent contractor kind of thing, right? So anyway, it's just concerning. I get concerned when I see coroner. You know, but they want her to be an expert. Okay, so for these other exhibits, the state disclosed forensic detectives. These disclosures specifically listed each forensic item to which the witnesses would testify regarding. Yeah, you know what that's not? That doesn't sound like disclosing an opinion, though. The witness's expertise is the process of extracting and identifying the data that is on each of the listed devices. The contents of each of these devices have been disclosed to the defendant. Any opinion related to that extraction, i.e. whether a connection was found or not, is not an expert opinion. What? What? Any opinion related to the extraction is not an expert opinion? What? Look, if you've got these people, forensic detectives, okay, and you put them, you as in the state, right, put them and listed them as expert witnesses, then they have to comply with the rule. And any opinion they give is therefore an expert opinion if you're disclosing them as experts. Why is this so hard? That's what she said. You're very welcome. Glad you're here. Happy to see you again. So this is crazy. I'm so shocked. I just combined the word insane and crazy. And what was I was going to say crazy is what I was like. I can't even speak. I'm just flabbergasted. Okay, for S12, the state disclosed an expert on crime scene reconstruction and bloodstain pattern analysis. The state specially detailed, I think they probably meant to say specifically, detailed each opinion to be proffered. The opinions were supported by attached reference report and CV. They keep saying CV as if that's that issue here. I can't. The state's disclosure provides defendant with adequate notice of this expert's anticipated testimony. It has to be all of their opinions. Why is this so hard? To satisfy the requirements. Oh my God, I cannot. enough for cross-examination. Again, in my opinion, that's not satisfactory. Exhibits S15 through S25 all relate to Idaho State Police forensic lab experts. First, the defendant claims not a single expert opinion. Right, they did say that. Not a single expert DNA opinion or report was produced. This is simply not true, dude. In each of these responses, the state refers the defendant to specific lab reports and the corresponding Bates numbers. Right, they said that. That's what they said you did. And that's not good enough. The defendant's apparent argument is that the state is required to make duplicative disclosures as unsupported. A simple reference to where a defendant can find the report is adequate. Each report provides a basis to determine what the expert's opinion is through the referenced lab report. Look at this. What they're saying is that the reports provide a basis to determine their opinion. This is crazy. Like, what this is saying is, instead of providing their opinion like we're supposed to, we're providing these reports, and that's only as it pertains to these certain experts, mind you, not even all of them. We're providing these reports, and in the reports, there's a basis to determine. In other words, it's up to y'all to determine it. Like, are you joking me? What? No, this can't be happening. Like, this is... Each report provides a basis to determine what the expert's opinion is through the reference lab report. Is this like a puzzle or like a scavenger hunt? No. What is happening? For S21, the state disclosed Riley Nowlin as an expert. It is anticipated that this witness is and there it is. I called it. What did I say before? Rebuttal witness, right? Who is prepared to testify regarding secondary transfer if necessary. That was what I was saying. I was like, that's one of the ways they could get around it. The state contends the notice provided is sufficient pursuant to the rule, but reserves the right to amend this disclosure upon review of the defendant's. Oh my God. Okay. Look, guys, look at this. Upon review of the defendant's guilt phase experts and pending discovery. That's why they're doing it. That's why they're doing this. That's why they're doing this. That's why they're doing this. Holy fuck. No, they need to be. This is crazy. Okay. So remember, the defense has this deadline of January 23rd to provide all their experts, right? But they can't do that. The way that this works, right? Hey, Santa, the way trial works, right, is y'all go first. You have a case in chief. You have the burden. You have the case in chief. The defense does not even have to put on a case, okay? But y'all go first, and then the defense goes, okay? And because of that, and also with the way discovery works, right, that the state provides a discovery to the way all these deadlines work, always in every trial, right, is it's like the state has a deadline first, and then there's the second deadline later, right, is the defense deadline to respond. It's not the other way around. There's not ever a deadline that the defense has first. Why? Because they don't have the burden. That's burden shifting. Everything that they do is in response to the state. Why? The state brought the charges. They wouldn't even be there if the state didn't bring the charges. The fact that we're even talking about this, right, is because the state first brought the charges. That's why these rules exist. But what this is saying is that they're saying right now, we're going to go ahead and just say that this expert, okay, is going to be in rebuttal because therefore this rule doesn't apply, right? But if they get the list of the defendant's guilt phase experts, right, which would be January 23rd, that's the date that they have now, right? Once they see who the defendant's going to call, look at this. They're switching it. Once they see who the defendant's going to call, then they might change their mind and say, this is not a rebuttal witness. No. Yeah. That's why they're asking for sanctions, because this is not, no. This is like saying that the defense, it's like as if it's the way the state is saying it's as if the defense is the state, right? Like we respond to what you do. because we don't have, like, do they not have, like, this doesn't make any sense because it's their job to put on a case, right? They have to put on a case. They can't just be like, you know, think of it as like offensive and defensive, right? It's like reacting, or like passive versus like, you know, what's the word I'm looking for? Passive versus active, or like proactive, like, you know, it's like one person makes it, or like a game of chess or whatever, right? Like one person's making a move, right? And then the other person's responding. The way that works in trial is the state is the first person, and then the defense responds. And it's like the state wants to flip it and be like, once we get the defendant's list of experts, then we'll decide if this person's going to be a rebuttal expert or not. I can't even. As required by Rule 16J, the state will continue to supplement the response if the state later discovers or decides to use additional evidence. They're trying to take these rules and warp them so that they can get around having to provide. But the question is this: why is it that they feel like they need to wait for that? Right? That's the part that's like that. Like, it's okay. That's not following the rules. That's shady. That's fucked up. That's messed up. All this other stuff, right? But beyond that, what is the reason for it? Right? Why is it that they can't? Like it doesn't make any sense. Like, do they not, like, if it's like, do they not have a picture of what their case in chief is going to be, to where they need to hear what the defense is going to be? And then, you know, we've seen this in other cases. What was an example of this? Like, where, well, Karen Reed would be kind of an example, right? Where, like, in the case in chief, so much of it is spent just trying to thwart what they know is going to be coming from the defense, right? And it feels like they're on the deep. It felt like reversed, right? Like, yeah, that would be a good example where, like, more than half the time, it felt like they were just defending against the case in chief, and that the case in chief was going to come from the defense. Like, it felt backwards, right? So it's like that. But that's not what's supposed to be happening, and that's not typical, right? Because they're supposed to have their case. I mean, and if Karen Reed is any example, when would this happen, right? When would this happen? Why would the state not have their actual case, but spend so much of their case just trying to ahead of time dispute what hasn't come in yet, but what they expect to come in from the defense? Like, that's for rebuttal, right? That's for rebuttal. So why would they spend their case in chief doing that? Well, I'll leave that as a rhetorical question for you guys to answer in your minds, or in the comments, or in the chat if you want. Lastly, if the court determines that any of the disclosed expert disclosures do not meet the requirements of the rule, the state will promptly amend. Any contention that the defendant has been prejudiced or does not have adequate time to respond is wholly unsupported. The defendant's request for sanctions is premature and without merit. Conclusion: deny their motion to compel, blah, blah. Wow. So given what we just went through, right? Remember how we were saying, I was just saying how it seems like the whole point is because this deadline is approaching for the defense. They want the defense to have to meet this deadline and turn over their list, and then they can decide. And then they can, you know, so here, and this makes sense, right? Now we have from the defense motion to extend time to disclose defendant's guilt phase experts, right? So this all makes sense, right? Because again, the state's guilt phase experts were timely disclosed. Remember, like I said, the defense had no problem with the timing. That's why it was so stupid that Santa made a big fuss about that initially. They didn't say that they were disclosed late. That was not the issue. Anyway, after reviewing the state's disclosure, they filed the motion to compel and sanctions. The motion to compel cannot be heard until January 23rd, which is also the deadline for disclosing their guilt phase experts. Until the state makes proper disclosures and the court issues a decision on Mr. Kohberger's motion, the defense cannot adequately respond to the opinions offered by the state's experts. Thus, Mr. Kohberger respectfully requests that the deadline be extended past January 23rd. The suggested deadline is 30 days after the properly disclosed, after the state properly discloses expert opinions, or at a reasonable time after the court hears. So, I mean, here you can see that, like, essentially, remember the sanction that they were asking for was just exclude all these witnesses, but clearly seems like they knew they were shooting for the moon on that one, right? Because if that was the case, they wouldn't need to be asking for an extension of the deadline. So, so extend the deadline for 30 days after they properly disclose all their expert opinions. Okay. Okay, so now we have the reply to the state's objection for the motion to compel. Okay. Presumption of innocence. I mean, again, all this goes without saying, right? He can't confront the evidence he doesn't have. His counsel can't be prepared. I mean, obviously, right? Failure to properly disclose expert opinions by merely disclosing a list or topics an expert may testify about, or leaving open-ended opinions, in essence, shifts the burden of Mr. Kohberger. Yeah, that's what I said. He's forced to respond to unknown expert opinions with unspecified scientific, technical, or specialized knowledge, while giving the state the ability to disclose its further or actual expert opinions in rebuttal filing. Yep. They can't be doing that. Like I said, it's like reversing the roles. This failure to disclose expert opinions not only prevents Mr. Kohberger from confronting the evidence against him, but also prevents him from assessing his need to file motions in limine and motions to exclude expert witnesses who do not meet Idaho's evidentiary standard. So like witnesses that are not adequate. Deadlines are looming. This motion cannot be heard until January 23rd. Motions in limine are due February 10th. Yeah, a motion to extend, right. So we just read that, right? Filed simultaneously. Arguments. The court has states sealed exhibits S1 through S25. The state's filing consists of over 400 pages, mostly curriculum vitae. Not surprising, because that's why Santa kept saying, we gave you the CVs. Dude, I can't. Mostly curriculum vitae of the named witnesses and very few details of expert opinions, with few exceptions. Approximately 2,000 pages of discovery are referenced in the DNA disclosures. The court does not have the discovery pages in the expert disclosures, but for one example. Wow. Most of the disclosures have catch-all phrases that the expert will rely on the work of unnamed others. Oh, God. Okay. This is, I'm just thinking here. So here's the thing. My voice is going. I don't know if you guys can tell, but my voice is going. This right here, though, ties right into what I wanted to also do on this live stream, but we're going to have to continue this probably tomorrow, which is the presentation I referenced at the beginning with the timeline, with the Elantra and the IGG and the DNA and all that. But having said that, there's also those additional filings that I referenced earlier too that haven't come in yet that might show up tomorrow because they were due to be filed yesterday. By that, I mean, at the very least, it would be the the witness list, the defense witness list for the hearing on the 23rd. So what I'm going to do is we will continue here tomorrow because I don't want to push my voice and then lose it again. So we will pick up with this because this is actually the last filing of all the ones that have come out at this point. So this will tie very nicely into what I wanted to go through with the timeline and the Elantra and the IGG. So that's what I'll do because I feel like it's my voice is going. So we will end it here for now, and maybe we'll do this tomorrow morning and cover the rest of this and go through all that stuff. So, but I find this all very interesting. And if some of the things that we've talked about on the other live streams, especially as it pertains to the IGG, not IGG, right? If there's I'm not, the question that is this: what reason would explain what the strange absence of evidence or absence of information or unwillingness to turn things over, like, and these decisions from the state, like what would explain it, and also maybe most importantly, what would explain this whole confusion with the Elantra and in the IGG? Again, we'll go over that tomorrow. Why is this so hard? And why is everything so vague? And it's like, but we do know that of all of it, the IGG is really at the heart of the biggest issue that seems to be going on, right? And and how do we know that? Well, because we know that their entire thing for the Franks hearing is IGG, and that the issues there are big enough, right, in the defense's view, that's what they're basing the Franks motion on, and that would exclude literally everything else because fruit of the poisonous tree. So anyway, but we will talk more about it tomorrow. And in other words, this whole thing with the state not turning over their expert witnesses with their opinions surprises me, right? And further than that, it's not just the not turning it over, but then saying we want to wait for the defense to submit their expert witness list. Like, I'm just, I don't even have words. I'm speechless. Like, this is crazy. I don't even know. I mean, there's got to be some reason that they deem good enough to make these types of requests and to these types of filings and to not turn this stuff over. Like, I don't know. Like, in my mind, it's like, dude, again, the appropriate sanctions, right? It's like best case scenario for them, they're going to have to just turn it over anyway. So, like, why are they procrastinating? And what, like, there is no benefit to be had. There's only downsides. Like, the only question is, like, how much in trouble are you going to be with the court? So why would you even bother to take that risk when it's not going to benefit you anyway? So I don't know, but those are the questions that I like. This is just really surprising and a lot. So anyway, but I'm going to go ahead and end the stream here before my voice goes completely. And thanks you guys for watching, and I will see you guys on the next one.